During the reading of my late wife's will, my son-in-law snarled, "All 7 oceanfront villas go to us. This worthless old man gets nothing." His family erupted in cheers, certain they'd outsmarted a helpless 6, 8-year-old retiree. I sat there calmly and told the lawyer, "You really don't know, do you?" I froze. What happened next turned their greedy victory into a nightmare of consequences they never saw coming. Before continuing, subscribe to our new channel, where we tell stories of husbands and wives taking revenge on their insolent children, sons-in-law, and daughters-in-law. My name is Raymond Foster. I'm 68 years old, and I live in Sarasota, Florida, where the salt air gets into your bones and never really leaves. I spent most of my career as a marine architect drawing hull lines for boats that other men would sail. When I retired, I opened a small marina on Bayshore Road, Blue Compass Marina, and spent my days restoring old wooden yachts in the back workshop. Most people my age slow down. I just changed what I was building. I'm not the kind of man who fills a room when he walks in. I'm not loud. I don't slap backs or tell the same story 3 times. But I notice things. Always have. It's a habit you develop when you spend decades reading water and weather, learning to spot the small signs before the big storm arrives. That habit, as it turned out, would matter more than anything in the months ahead. I was married to Grace for 41 years. Some things don't need explaining. She passed away in early March, and the house on Pelican Point Drive on Longboat Key, the one with the wraparound porch and the water view she never got tired of, went very quiet after that. 2 weeks later, I was sitting in a leather chair on the 3rd floor of 1840 Ringling Boulevard, Suite 300, watching a woman named Sheila Vasquez open a manila folder. And that's where this story really begins. Let me tell you about my son-in-law, Daniel Garner, because you need to understand what kind of man he is before you can understand what happened in that room. Daniel married my daughter Nicole 9 years ago. He was 30 at the time. Lean, well-dressed. The kind of man who makes solid eye contact and says all the right things at dinner parties. I remember thinking he was a bit too smooth, the way a freshly painted hull looks perfect until you get it in the water. But Nicole was happy. She was 27, running her own interior design studio, and she looked at him like he was the answer to something she'd been asking for a long time. The first few years were fine. He'd call me Raymond, not Dad, which I respected. Clear boundaries. I can work with that. He was doing something in real estate sales over in Tampa. Nothing spectacular, but building something real. We'd have Sunday dinners. He'd ask about the marina. Nicole would talk about clients. Normal. Then Grace got sick. Gradually, the way these things happen. And something shifted in Daniel's behavior. So slowly. I almost didn't catch it. Almost. It started with suggestions, reasonable-sounding ones. "Raymond, you should think about consolidating the properties. Simplify things in case something happens. Then have you ever thought about a trust for estate planning purposes?" He'd bring it up over coffee, his voice smooth and helpful, concerned. I'd nod, say I'd think about it, and watch him for a moment when he thought I wasn't looking. What I saw was a man doing math. The condescension came later, subtle enough that I could never call it out directly without sounding paranoid. He'd reference my age in rooms full of younger people. "Raymond's a little old-fashioned about this stuff," he'd say with that practiced half-smile. Or during a conversation about the real estate market, he'd wave his hand. "Dad, you don't really understand how it works now." He always said Dad when he was dismissing me. Never. When he was being genuine, Nicole went along with it. That was the part that cut deepest. She'd look away, or change the subject, or laugh too quickly. She'd convinced herself that her father had more than enough, and whatever arrangements the future held were just practical, nothing personal. Daniel's mother, Christine, was a whole separate chapter, a 62-year-old widow who'd spent 20 years in real estate and understood exactly how titles and documents worked, always present at family events, always watching, always positioning herself at the edge of conversations about the properties complementing the villas, while simultaneously cataloging them. I always notice. The morning of the reading of the will, I put on my navy blazer and drove myself to Ringling Boulevard, parked on the street, took the elevator to the 3rd floor. Daniel and Nicole were already there. Daniel stood by the window in a charcoal suit, looking at the street below with the energy of a man who'd already decided how the meeting would go. Nicole sat near the conference table, hands folded, not meeting my eyes when I walked in. Christine was positioned just behind Daniel's right shoulder, a formation I recognized immediately. The chair closest to Sheila's desk, the premium seat, had Daniel's leather portfolio on it. He'd claimed it before I arrived. I sat across the table, set my hands flat on the wood, and waited. Sheila Vasquez opened the folder, adjusted her reading glasses, and began with the standard language. Full legal name of the deceased, date of the document. Declaration of intent. She hadn't finished the second paragraph when Daniel spoke. We already know the structure. His voice had the patience of someone performing patience for an audience. The 7 oceanfront properties passed to Nicole and me. That's the substance of it. He glanced at me briefly, like you. Glance at furniture you're considering moving. The old man doesn't need to worry about any of it. Christine made a small sound behind him that might have been a laugh. Nicole looked at the table. 2 seconds of silence. I looked at Sheila Vasquez. She was watching me with an expression I couldn't quite name. Not surprise, but something adjacent to it. Like she was waiting to see what I do. You really don't know, do you? I said quietly. Sheila's pen stopped. Her eyes dropped to the folder. She flipped past the main document slowly, until she reached a tabbed section near the back. She pulled it free and placed it on the table. It was a separate folder, cream-colored, with a label in clean block letters. Fidelity Trust Account. Raymond L. Foster, Trustee. Sheila looked up. The room held its breath. I want to go back for a moment. Before Sheila said a word, before Daniel's expression changed 3 years earlier on a Tuesday afternoon in February, Grace and I sat in a quiet downtown office and signed the paperwork that reclassified everything. She'd spent 2 evenings reviewing the documents with an attorney she'd found on her own. She was thorough like that. She came to me with a specific proposal, documents already drafted, and said, I want to know we did this right. A revocable living trust under Florida law. Every property transferred by deed into the trust. Nothing that would pass through probate. No court, no delay, no window for anyone to contest distribution because there was no estate proceeding to contest. Grace had understood something I hadn't fully articulated. The people circling us weren't going to wait politely. They'd used the legal machinery of grief, the confusion of paperwork, the exhaustion of loss as their opening. She closed the opening before she was gone. She signed the final page without ceremony, kept the pen, looked at me. Now we know, she said. I thought about that sentence a lot in the 2 weeks after she passed. Back in Sheila's office, the silence lasted maybe 4 seconds before it ended. That's Daniel started, then stopped. He cleared his throat. What is that? Sheila lifted the folder and opened it to the first page. This is a revocable living trust executed 3 years ago under Florida Trust Code Chapter 736. All real property owned jointly by Grace and Raymond Foster was transferred into this trust at that time. She paused. The properties in question were no longer part of the marital estate. They are not governed by the will. Daniel laughed. It came out sharper than he intended. That can't be right. We would have known about something like that. Would you? I said. I didn't raise my voice. There was no need. Christine stepped forward from behind her son's shoulder. Documents like this can be fabricated, backdated. We should have an attorney look at this before anyone does anything. She was using her professional voice, the practiced calm of someone who'd spent 20 years managing difficult negotiations. But I noticed her left hand, the one holding her purse strap, had gone white at the knuckles. Sheila reached into the folder and withdrew 3 sets of notarized copies, each one stamped with the seal of the notary who'd witnessed the signing on the 12th of February 3 years earlier. She placed them on the table, fanned out, evenly spaced. These are certified copies, she said. The originals are on file. Nicole had gone very still. She was looking at the documents with a particular kind of pale. Not shock exactly, but the color of a calculation going wrong. Daniel picked up one of the copies, scanned it, set it back down, picked it up again. I stood up, buttoned my jacket. Now you know, I said. I walked toward the door. Daniel moved fast. His chair scraped back across the floor. He stepped into the hallway and grabbed my sleeve. You think you've done something here? His voice was low controlled, but I could hear what was underneath it. I looked at his hand. He let go. I know, I said. Then I turned left down the hall toward the elevator. He turned right, phone already out before he'd taken 3 steps. On the 5th floor of 18,000 and 2nd Street in the offices of Clayton and Marsh Trevor, Clayton was already waiting. I'd called him 4 days earlier. I drove back to Longboat Key and stood on the back porch for a long time. The water was doing what it always does. Moving, shifting, reflecting light, and letting it go. I know the specific stillness that arrives just before conditions change. I knew this kind of stillness. There are moments when you realize that something you thought you'd avoided has been building anyway, just out of sight, and now it's arrived on your doorstep in a suit and a leather portfolio. I'd spent years telling myself that Daniel was just abrasive, just ambitious, that Nicole would find her footing in her own time. I'd given the benefit of the doubt until the doubt no longer deserved it. I thought about the Sunday dinners from the early years, when Nicole would laugh at something I said about a boat I was restoring, actually laugh the way she used to as a kid. When Daniel would ask questions about the work and seem for a few minutes to mean them. I'd held on to those evenings long past the point where they were still true. Somewhere along the way, I'd stopped being her father in Daniel's version of the family and become a problem to be managed until the assets transferred. The shift was so gradual I'd almost accepted it as normal. Almost. I went inside, sat at the kitchen table, and opened the folder Trevor had given me. 2 documents, a summary of the trust structure and what it protected, and a single page listing the assets now under my sole control. 7 properties along the Florida coast. Total assessed value approximately $14.2 million. I read both pages twice, then made a cup of coffee, went back to the porch and sat with the dark water and the distant sound of the marina. By the time I'd finished the coffee, something had crystallized. Not anger. I've never found much use for anger on its own. Something colder and more useful. The understanding that this situation had a shape, and that shape had vulnerabilities, and that I had both the time and the patience to find each one. The next morning I drove to the marina early. In the back workshop under fluorescent lights, the old wooden hull of the Lady Beatrix sat on its cradle, half restored, waiting. I picked up a piece of sandpaper and started working on the port side. My phone buzzed just before 9. A text from Trevor. 7 words. Certified letter waiting at my office, Daniel's attorney. I set down the sandpaper, looked at the hole for a moment, then I picked up my keys. The letter was 11 pages long. Trevor had it laid out on his conference table by the time I arrived, printed, tabbed, marked in 3 places, with a yellow highlighter. He sat across from me in the kind of deliberate quiet that attorneys use when they want you to read before they explain. So I read. The claim was this: Grace Foster, at the time she executed the revocable living trust, had been experiencing cognitive decline brought on by prolonged emotional distress, that her judgment had been impaired, that she had been, in the careful language of the filing, unduly influenced by her husband, Raymond L. Foster, trustee, who stood to gain the entirety of the estate's most valuable assets. I set the document down when I finished the last page. How strong is it? I asked. Trevor leaned back. On paper thin. They have no medical records from the signing period. No contemporaneous witnesses to any alleged incapacity. What they're banking on is the standard probate challenge strategy. File something credible enough to force a court review, then use the discovery process to go fishing. He paused. It can drag on up to 8 months before we get a ruling, depending on the court calendar. And the trust intact, protected under Chapter 736. The burden of proof is on them. They need to demonstrate that Grace lacked capacity or was under undue influence at the specific moment of signing. Not generally, not occasionally, not once in 2019. At that moment, he tapped the document. That's a high bar. I told him to proceed with the defense. We shook hands. I took the elevator back to ground level and stood for a moment on the sidewalk outside 8002nd Street, letting the March sun do what Florida sun does. Press down on the back of your neck until you remember where you are. 8 months. I could work with 8 months. 3 days later, my phone rang while I was in the workshop at the marina. Nicole's number. I let it ring twice, then answered. Dad. Her voice had that particular flatness that people get when they're reading from a script. Daniel and I have been talking. The house on Longboat Key. It's just sitting there. It doesn't make sense for it to be empty while all of this is being sorted out. We thought we'd stay there temporarily just until... No, I said. A pause. It's not, legally, it's not clear-cut right now. We just think it would be practical to... Nicole. I kept my voice level. I heard what you said. The answer is no. Another pause, longer this time. Then we're coming tomorrow. I set the phone down and looked at the Lady Beatrice for a moment. At the port side, I'd been working on the wood grain, still rough where I hadn't finished sanding. Then I picked up the phone again and made a different call. They arrived the following afternoon. I watched from the end of the driveway as Daniel's gray SUV pulled up to 4,417 Pelican Point Drive. He got out first, moving with the confidence of a man who's already decided a conversation is over. Nicole followed, her arms crossed the way she crosses them when she's braced for something but doesn't want to show it. They had luggage, actual suitcases, not overnight bags. I was standing on the porch. Raymond. Daniel used his business voice, the one that's meant to signal that the conversation is already settled and this is just the formality. We're not here to argue. We just need access to the property while the estate matter is pending. It's a reasonable request. I looked at him, then at Nicole, then back at the driveway. That's private property, I said. You're not on the list. Daniel's jaw tightened. The court hasn't ruled. The court doesn't need to rule on who lives in trust property. The trustee decides that. I took one step back toward the door. I'd suggest you find somewhere else to stay tonight. He took 2 steps forward. We have as much right to be here as you do. More actually, once this trust gets thrown out. Daniel, I said it quietly, the way you say something when you're done explaining. You're trespassing. He laughed. Short, sharp, disbelieving, the laugh of a man who thinks he's the only adult in the room. You're going to stand there and tell me. I'm not going to tell you anything else. I went inside and closed the door. The next morning I didn't need to do anything. The knock I'd been expecting came at 8:42. Not from Daniel, but from the Sarasota County Sheriff's deputy, a tall man in his 40s with a clipboard and the resigned expression of someone who delivers documents for a living. He handed me my copy of the served notice, the trespass warning, and explained in brief professional terms what it authorized. As trustee and sole authorized resident, I had the right to exclude any third parties from the trust property immediately and without further court order. I thanked him. He nodded. He left. I stood on the porch and watched Daniel and Nicole load their suitcases back into the SUV in the driveway. Daniel's movements were stiff, controlled, the body language of a man performing composure. Nicole didn't look at the house when she got in the passenger seat. They drove away. I went back inside, made coffee, and sat at the kitchen table with the deputy's paperwork and the trust summary side by side. That's when I started making notes. There's a particular kind of opponent who's dangerous not because they're strong but because they're patient. Daniel was loud and fast and sure of himself. Christine was none of those things. Christine was 62 years old and had spent 2 decades working real estate closings in Tampa, which means she'd watched 100 disputes over property and she knew exactly which pressure points mattered. A week after Daniel and Nicole were removed from the Longboat Key House, Christine got to work. I know this because Trevor told me he'd received an inquiry from a title researcher. Someone asking questions about the chain of ownership on 2 of the 7 properties. Specifically looking for any gaps in the documentation. Any transfers that might have occurred before the trust was executed. Professional, quiet, methodical, the kind of inquiry that doesn't raise flags unless you're paying attention. Trevor was paying attention. She's looking for an angle, he told me during our next meeting, something in the property history that could support the argument that the trust was assembled improperly or that certain assets shouldn't have been included in the first place. He pulled a sheet from his folder. My recommendation: we get a full title review done on all 7 properties within the next 2 weeks ahead of whatever she finds. I told him to do it. The review cost $4,200. I signed the check without hesitation. The title review came back clean. Every transfer properly documented, every deed recorded in sequence. No gaps, no anomalies, nothing that Christine or anyone else could use to create doubt in front of a judge. I wasn't surprised. Grace had been thorough. 2 weeks after the title inquiry, something new arrived through Trevor's office. Daniel had retained a private investigator, a man named Kenneth Foley. According to the retainer filing that Trevor obtained through discovery, Foley's stated assignment: locate and obtain medical records relating to Grace Foster for the calendar, years 2020 through 2022. I read that part twice. The theory was straightforward enough. Daniel needed a doctor, some physician who treated Grace during that period, willing to say under oath or in a written declaration that she'd exhibited signs of cognitive difficulty at some point near the trust signing. Even a single note in a file taken out of context could be spun into something that sounded like evidence. It was a reasonable strategy, not a strong one, but reasonable. I told Trevor I understood. Then I told him something else. I want to hire someone too. Trevor looked at me with the measured expression of a man who's learned not to react until he has all the information. For what purpose? Background on Daniel's business activities, specifically the real estate work in Tampa. He was quiet for a moment. That's a different kind of inquiry. I know what kind it is. He gave me a name. Garrett Sims, 52 years old, former financial crimes investigator, now in private practice in Clearwater. Licensed, bonded, discreet. Trevor had used him twice before on matters involving asset tracing. He wasn't a friend of Trevor's, just a professional Trevor had found to be reliable. I called Garrett Sims the following morning from my office at the marina with the door closed and the dock noise filtering in through the window. He answered on the third ring, with the flat, unhurried tone of someone who handles unusual requests for a living and hasn't been surprised by one in a while. I explained what I wanted: a review of Daniel Garner's business operations, specifically any financial patterns associated with his real estate transactions over the past 4 to 5 years. Anything that didn't follow the standard structure of a legitimate deal. Garrett asks 2 questions. The second one was, "What's your timeline?" 2 weeks. I said 3, if you need it. 2 should be enough. He quoted me a flat fee of $3,500. I told him where to send the agreement. I want to be honest about something. When I hung up the phone that morning, I didn't feel righteous. I didn't feel like I was executing some plan I'd had waiting in reserve. What I felt was something closer to the sensation of picking up a tool you've used before and remembering how it fits in your hand. Methodical, practical, appropriate to the work that needed to be done. I went back to the workshop and sanded the Lady Beatrix for 2 hours. The wood under my hands was white oak, old, dense, resistant, the kind of material that doesn't give easily but holds its shape once it's properly worked. I've always liked that about old boats. They show you exactly what you're dealing with. On the other side of the bay in Tampa, Daniel and Nicole were paying $3,800 a month for an apartment they hadn't budgeted for, and running a legal strategy that was costing them probably twice that in attorney fees. Daniel's private investigator was looking for medical records that weren't going to say what he needed them to say, and Christine was working her contacts and finding nothing. Meanwhile, I was sanding a boat. 11 days later, Garrett Sims pulled into the Blue Compass Marina parking lot at 10 inches the morning and walked into my office with a manila folder under his arm. He set it on the desk, sat down across from me, and said nothing for a moment. The kind of silence that means what he found was significant. Then he opened the folder. "Daniel Garner has an account in Bize," he said. Garrett Sims didn't editorialize. That was the first thing I'd noticed about him when we met, and it proved consistent. He spread the documents across my desk at the marina, 12 pages organized into 3 sections with paper clips, and walked me through them the way a contractor walks a client through a structural report. Here's what's there. Here's what it means. Here's the problem. The structure was simple, which made it more elegant than I'd expected from someone like Daniel. Over 4 years, he had been routing client earnest money deposits through a shell consulting firm registered in Florida under the name GH Advisors, LLC. The firm had no employees, no office, no website. It existed solely to receive wire transfers from escrow accounts and send a reduced amount back to the original destination, minus a consulting fee that appeared in no legitimate contract. The remainder moved through 2 intermediary transfers before arriving at a Bizian account registered to a holding company whose beneficial owner, after some digging, traced back to a second LLC in Nevada with Daniel Garner listed as its registered agent. Total accumulated over 4 years, $341,200. Garrett sat down the last page and folded his hands. "This isn't the kind of thing that stays hidden indefinitely," he said. "The paper trail is cleaner than most I've seen, but it's there. Anyone with subpoena authority in 6 weeks could reconstruct the whole thing." "Finninson," I said. "Finninson covers the federal angle. The Florida Department of Business and Professional Regulation handles the real estate license side. Either one is sufficient together." He left the sentence where it was. I looked at the documents for another moment. 12 pages. 4 years of patient, methodical misdirection that had funneled $341,000 away from clients who'd trusted Daniel Garner to handle their money correctly. Not something you do by accident. Not something you do once and stop. I gathered the pages, tapped them into a neat stack, and placed them in a manila folder. Then I put the folder in the lockbox bolted to the floor of my office closet. "What do I owe you for the additional work?" I asked. The original retainer covered it. Garrett picked up his jacket. "If you need anything else, call." I went back to the workshop. The Lady Beatrice was waiting. The portside planking still needed 2 more hours before I could move to the caulking stage. I put on my work gloves and got to it. There is something clarifying about physical work when you're carrying complicated information. The sandpaper moves. The wood gives slightly. The grain reveals itself under pressure. You don't have to think about what you know. You just hold it. What I knew was this. Daniel Garner had been stealing from his clients for 4 years. Carefully, methodically, with the patience of someone who thought it through and decided the risk was acceptable. That told me something about how he thought about risk generally. He was also paying $3,800 a month for an apartment he hadn't budgeted for, paying Philip Weiss for a lawsuit that was losing ground, and paying Kenneth Foley to look for medical records that weren't going to say what he needed. And underneath all of that, he was maintaining a Blaine account holding $341, $200 that he couldn't touch without drawing exactly the kind of attention he'd spent 4 years avoiding. I sanded the oak planking and thought about pressure, about what it does to a structure over time. Trevor's reaction the following morning was exactly what I expected. He read every page twice, set the folder down, and was quiet for a moment. "This is significant," he said. "I know. You understand that how you use this matters as much as what it is. That's why I'm showing it to you first." I leaned back in the chair across from his desk. "I want it ready. I don't want to use it yet." He nodded slowly. "If this goes to the relevant authorities before the lawsuit resolves, Daniel's attorney will claim you're retaliating, trying to muddy the civil proceedings. The optics are bad even when the substance is legitimate." He tapped the folder. "But if Daniel is the one applying pressure, trying to force a settlement through intimidation rather than legal merit, then the table is right," I said. Trevor allowed himself a small, precise nod. I took the folder back, drove to Longboat Key, and locked it alongside the trust documents in the safe in the study. That evening, Trevor called with news from the courthouse. The judge had reviewed Daniel's submission treatment notes from Grace's primary care physician from 2 years before the trust was signed, referencing a difficult period following a cancer diagnosis that had ultimately been resolved. Daniel's attorney had characterized this as evidence of ongoing cognitive vulnerability. The judge was not persuaded, but he was cautious. He ordered an independent psychiatric evaluation, a retrospective capacity assessment, meaning a specialist would review all available medical records and testimony to determine whether Grace had possessed full legal capacity at the time of the trust signing. The hearing was scheduled for 1 month out. According to Trevor, Daniel had described this ruling to his attorney as a victory. I read that line twice and decided that Daniel and I had very different dictionaries. I went back to the marina. The caulking on the Lady Beatrice was coming along well. The Sarasota County Courthouse at 2000 Main Street is a building that does not try to impress you. Practical, civic, worn at the edges, in the way buildings get after 30 years of processing other people's problems. I arrived 20 minutes early. Trevor came in 5 minutes after and took the chair beside me at the respondent's table. Binder, legal pad, the focused calm of someone who had prepared and knew it. Daniel and Nicole arrived together. Their attorney, Philip Weiss, mid-50s theatrical hand gestures leading them to the petitioner's table. Daniel wore a suit I hadn't seen before. Dark blue, expensive. The kind that announces itself. He sat without looking at me. Nicole looked at the table instead. Christine was in the gallery 3 rows back. She caught my eye once and looked away first. The judge was a woman named Harrove, efficient, unhurried, with the manner of someone who has heard every version of every family dispute. Weiss led off for the petitioners. His argument centered on the treatment notes that Grace had experienced a significant emotional episode during a difficult medical period, that a licensed physician had documented this, and that it raised reasonable questions about her capacity when she executed the trust. He used vulnerable state 4 times and undue influence twice. Then Trevor stood up. He called Dr. Marion Webb, a psychiatrist who had evaluated Grace at Grace's own request. The February before the trust was signed, Dr. Webb was 60 precise and uninterested in being misunderstood. She explained that Grace had come specifically to establish a contemporaneous record of her psychological and cognitive status before undertaking significant legal decisions. Grace had been in Dr. Webb's assessment fully oriented, logically consistent, and entirely clear about the nature and consequences of what she intended to sign. She had asked Dr. Webb specific questions about what the evaluation would document and whether the record would be accessible in legal proceedings. Grace had planned for this. Of course she had. The gallery was quiet while Dr. Webb spoke. I kept my eyes on the front of the room and did not look at Daniel, but I was aware of him, the way you're aware of a shift in weather, through peripheral pressure rather than direct observation. Weiss cross-examined for 11 minutes. He got nothing useful. When Dr. Webb stepped down, I permitted myself a single glance at the petitioner's table. Daniel's jaw was set in the way it gets when he's working to contain something. Nicole was still her eyes forward, wearing the expression of someone who has just understood something she'd been hoping to avoid. Judge Hargrove reviewed her notes, then addressed the courtroom. The retrospective assessment would proceed, but the burden of proof remained with the petitioners, and the testimony that morning had substantially narrowed the evidentiary space available to support their claim. She would expect compelling new documentation, not further characterization of existing records, before she would consider the challenge to have merit. Not a ruling in our favor, but as close to a warning as judicial language permits. We were waiting for the elevator outside courtroom 4B when Daniel appeared. He'd sent his attorney ahead. He stopped beside me. You think you're ahead? Low controlled. One doctor, one hearing. That's not a win. His free hand was slightly closed at his side. Not a fist, just tension collecting where the rest of the body was under instruction to stay still. I know, I said. We have resources you haven't seen yet. This goes another 6 months and you'll get tired before we do. I said nothing. He held eye contact for 2 seconds, then walked away. The elevator arrived. I stepped in. On the drive back to the marina, I thought about what resources you haven't seen yet. Sounds like when a man says it in a courthouse hallway after his attorney's argument has just been dismantled by a psychiatrist. It sounds like someone running short on actual options and compensating with confidence. I parked in the marina lot, walked through the main building, and opened the workshop door. Then I stopped. The plate glass window facing the parking lot was gone. The frame was intact. The glass was spread across the entrance walkway in a wide, irregular field. Spray paint red, hasty, covered the lower half of the exterior wall beside the door. 3 words legible. A Sarasota PD officer was already in the lot. Speaking with my dock manager, he looked up when I approached. You the owner? I am. Any security cameras on the exterior? 2, I said, both recording continuously. I pointed to the units above the entrance. I can pull the footage right now. The footage was clear. Recorded at 2:14 inches the morning. One figure, young, moving fast face, partially obscured by a hood, but the jawline and build caught cleanly in the parking lot light. He swung a tire iron at the glass, handled the spray can in under 90 seconds, and jogged toward a car parked at the curb. The car pulled away before the plate was visible, but the build was visible. The jaw was visible. I'd seen that jaw before at family dinners years ago when Daniel used to bring his nephew along. The nephew's name was Caden. He was 22 now. I saved the footage to 2 drives, locked one in the office safe next to Garrett's folder, and sent a copy to Trevor. His reply came in 4 minutes. Keep everything. Don't speculate in writing yet. I'll call tomorrow. I sat in my office for a moment looking at the still frame on the screen, that jawline caught clean in the parking lot light. I'd seen it before at family dinners years back when Daniel used to bring his nephew Caden along. 22 now. Same jaw. I closed the laptop. Some things you address immediately. Some things you let sit until the moment is exactly right. The police report was filed the morning after the vandalism. The officer who took my statement was professional and efficient. He documented the broken window, the spray paint, the timeline established by the security footage, and the estimate for repairs. $2,400 for the glass alone. He told me the department would review the footage and follow up. I thanked him. Then I went to my office, made a copy of both drives, and sent the second copy to Trevor with a note. Caden Garner, Daniel's nephew. Review the footage at 2:14 a.m. Trevor called back within the hour. He'd watched it. He agreed on the identification cautiously because a hood and a parking lot camera at that hour don't produce courtroom-grade certainty, but agreed that the build, the gait, and the jaw were consistent with a 22-year-old male of Caden's description. "This is a criminal matter," Trevor said. "Vandalism under Florida Statute 86.13. The police have jurisdiction. We don't need to drive this. We just need to make sure our documentation is preserved and submitted." "It's already submitted," I said. "Then let the process work," he paused. "What I'm more interested in is whether Daniel knows that you know." I told him Daniel didn't know yet. As far as Daniel was concerned, the vandalism was anonymous, a message sent from a safe distance. "Good," Trevor said. "Let him think that for a few more days." 2 days later, a letter arrived through Prescott Walsh's office. Formal, structured, addressed to Trevor Clayton on behalf of Raymond Foster. It proposed the settlement. Daniel Garner would withdraw the trust challenge in full, and in exchange Raymond Foster would voluntarily transfer title on 2 of the 7 properties. The Gulfside Villa in Siesta Key, valued at $1.8 million, and the smaller unit in Venice at $620,000, a total concession of $2.42, $42 million. I read the letter twice. The math was interesting. 2 properties, $2.42 million total, in exchange for dropping a lawsuit he'd already been losing on its merits. It was framed as a compromise. Both sides giving something, neither side fully winning. That's how these things get dressed up when one side is desperate and the other side is holding cards they don't know about yet. What the letter didn't know was that the glass on the marina window had cost $2,400 to replace. What it didn't know was that Garrett Sims had spent 11 days tracing shell companies and offshore accounts. What it didn't account for was the fact that I had been waiting, specifically deliberately waiting for the moment when Daniel was in exactly this position, running out of legal ground, running out of patience, reaching for a shortcut. Shortcuts are useful. They tell you exactly what someone thinks they can get away with. Then I called Trevor and said 4 words. "It's time. Use it. I want to be precise about what happened next, because it matters." Trevor did not threaten Daniel. He did not make accusations. He sent a letter professionally worded, factual, without editorial commentary, to Prescott Walsh. The letter contained 3 attachments: the GH Advisors LLC, corporate registration documents, the transaction records Garrett Sims had compiled, showing the routing of $341,200 through the shell company, and the correspondent banking documentation linking those transfers to the Blaine account. The cover letter stated one thing clearly: this documentation, which relates to potential violations of federal financial reporting requirements and Florida real estate licensing regulations, may be transmitted to the Financial Crimes Enforcement Network and the Florida Department of DAGE, Business and Professional Regulation, within 72 hours. Unless we receive written confirmation of the full and unconditional withdrawal of the trust challenge petition by 7:00 Friday evening. It was sent on a Wednesday morning. Wednesday passed. I went to the marina, worked on the Lady Beatrice, checked my phone twice. The portside caulking was coming along. The wood was taking the compound cleanly. Thursday morning passed. I drove to the hardware store, picked up a new set of clamps, stopped for coffee at the place on Main Street that I've been going to for years. The woman at the counter asked how I was doing. I told her fine, and meant it more than I had in a while. Thursday afternoon, I was back in the workshop when the phone rang. It was not Daniel's number. It was not Prescott Walsh's office. It was Nicole. I set down the sandpaper and looked at the screen for one full ring. Her name, the number I'd had memorized since she was old enough to have her own phone. I answered, "Dad." Her voice was careful in a way that suggested she'd been thinking about how to say the first word for a while. "I need to talk to you." "All right," I said. "Not on the phone. A pause. Can I come to the marina tomorrow morning?" I looked around the workshop at the half-restored hull, the tools laid out on the workbench, the afternoon light coming in through the high windows. 9:00, I said. She arrived at 5 minutes to 9, which told me she'd left Tampa early enough to account for traffic and still arrived with time to spare. She was wearing a gray jacket over jeans. Not her design client clothes, not her going-out clothes, the clothes of someone who wanted to look like herself, rather than a version of herself she was presenting to an audience. I met her at the parking lot entrance and walked her to my office. I didn't offer a tour of the workshop, didn't make small talk about the boat. She sat down in the chair across from my desk. I sat across from her. Between us, the surface of the desk clear, except for a coffee mug and a notepad. She looked at me for a moment before she spoke. I didn't know about the account, she said. I know, I said. She blinked. You believe me. I've known you for 36 years, Nicole. I know what you look like when you're lying, and I know what you look like when you're not. I kept my voice level. You didn't know about buys. Something shifted in her face. Relief. And then immediately something harder. I found out 3 days ago when Prescott Walsh called Daniel and told him what was in your letter. She stopped. He didn't tell me. He left the room to take the call, but I heard enough. Later, I made him show me the documents. She looked at her hands. 4 years, Dad. He's been doing this for 4 years. I waited. I don't understand all of it, she said. The legal part, but I understand enough. She looked up. He thinks he can find a way through it. He's already calling other attorneys. He thinks if he restructures the LLC and moves things around, he can try. I said the documentation has already been preserved. Moving money now doesn't erase the transfer history. She absorbed that. What does this mean for him? That depends on decisions he makes in the next 48 hours. I picked up the coffee mug, set it back down. If he withdraws the lawsuit, the documentation stays in my safe. That's the arrangement that's on the table. And if he doesn't, then Trevor transmits it to Finninson and the DBPR, and Daniel's situation becomes significantly more complicated than a civil lawsuit. Nicole was quiet for a long time. The dock sounds filtered in through the window, the soft knock of holes against moorings, water moving a gull somewhere over the lot. I want to ask you something, she said finally. And I want you to answer honestly. All right. Did you do any of this to hurt me? I looked at her, the daughter who used to bring me drawings of boats when she was 6 years old and taped them to the workshop wall, the woman who'd sat in Sheila Vasquez's office and stared at the table while her husband announced she was about to inherit everything. No, I said, I did this because what Grace and I built together belongs to us, not because I wanted anything taken from you. She looked at the window for a moment, then back at me. I'm going to withdraw from the lawsuit, she said, from my part of it. I have my own attorney now. Not Walsh. Someone I found myself. She set her hands flat on the desk, a gesture I recognized because I make the same one. I should have done this sooner. You're doing it now, I said. She left 40 minutes later. I walked her to the parking lot, watched her car turn out onto Bayshore Road, and stood in the lot for a moment after it was out of sight. Then I went back inside and called Trevor. Nicole's withdrawing, I said. She has separate representation. Expect the filing within the next day or two. Trevor was quiet for a moment. That weakens Daniel's standing significantly. As a copetitioner, Nicole had standing as Grace's daughter. Without her, Daniel's arguing as a son-in-law with no direct blood relationship to the deceased. The bar just got higher. I know, I said. Raymond, he paused. Friday's deadline is still in play. Daniel hasn't responded. I know that too. I hung up, went back to the workshop, and spent the rest of the afternoon on the Lady Beatrice. The caulking was holding well. The port side was nearly finished. Friday morning arrived. Then Friday afternoon I worked at the marina and waited. At 6:47 inches the evening, 13 minutes before the deadline, my phone buzzed with a message from Trevor. Walsh's office just called. Daniel's withdrawing confirmation in writing by end of business Monday. I read it twice. Then I set the phone face down on the workbench, picked up a brush, and continued what I was doing. But the following Monday before the confirmation arrived, something else happened first. Trevor called early. We have a problem, he said. Daniel filed a complaint with the Sarasota City Commission. Anonymous submitted electronically alleging code violations and improper licensing at Blue Compass Marina. He paused. He's not letting go quietly. I looked out the workshop window at the dock, the water, the boats I'd been maintaining and repairing for years. Every license current, every inspection passed, every document filed correctly. When's the inspection, I said. They'll send someone within the week, Trevor said. Good, I said. Let them come. The inspector arrived on a Tuesday morning. A compact man in his 50s, named Gerald Pham, from the Sarasota City Development Services office. He had a clipboard, a camera, and the neutral, unhurried manner of someone who has conducted several hundred of these visits and has learned not to arrive with expectations in either direction. I met him at the parking lot entrance and walked him through everything myself. I didn't send my dock manager. I didn't hand him a folder and disappear. I walked with him because I wanted him to see that I had nothing to avoid. We covered the main building, first the office, the customer check-in area, the storage room, every fire suppression certificate current, every exit marked and unobstructed, the electrical panel labeled and properly logged. Then the dock slip assignments documented safety equipment in place at each station, the fuel dock equipped according to the relevant Florida Fire Prevention Code specifications. Then the workshop ventilation-compliant chemical storage in the correct cabinet types. No unauthorized modifications to the structure. Gerald Pham made notes. He took photographs. He asked 3 questions, all of which I answered directly. And I showed him the documentation before he finished asking the 3rd one. At the end of the walkthrough, he stood near the parking lot entrance and reviewed his clipboard for a moment. He flipped back through his notes, checked something on the 2nd page, then looked up. "Everything appears to be in order," he said. The phrasing of a man who was reporting a finding, not expressing surprise. "I know," I said. He thanked me for my time and left. I watched his city vehicle pull out of the lot and turn on to Bayshore Road. Then I went inside and called Trevor. "Clean inspection," I said. "I assumed it would be," Trevor said. The complaint was filed electronically submitted to the city's online portal. The author used a Gmail address, no name attached, but the document itself was a Word file. "Metadata," I said. "Exactly." The document properties list the author as D. Garner. Last modified from a device registered to an account associated with Daniel Garner's real estate brokerage. Trevor's voice had the flat precision it gets when he's presenting facts that don't require additional emphasis. Filing a false complaint with a municipal agency is a misdemeanor in Florida. It doesn't carry significant criminal weight on its own, but combined with the vandalism charge against Caden and the existing civil record, it adds texture. "Pressure," I said. "Pattern," Trevor said. "Which is more useful." I thanked him and hung up. 2 days later, Trevor called me back. "I had a conversation this morning," he said. Christine Garner's attorney reached out directly. Apparently, Christine was a signatory on one of the GH Advisors operating agreements. She co-signed a document in the first year of the company's existence when the LLC was being set up. She may not have understood the full structure at the time, but her name is on it. I sat down in my office chair. "What does she want?" Her attorney was clear. "She is not interested in continuing this dispute. She has communicated to Daniel in the strongest available terms that he needs to withdraw the lawsuit in its entirety. She is not willing to have her name appear in any regulatory filing." A pause. "I think you should know that this call was initiated by Christine's attorney, not Daniel's. She's acting independently of her son." I thought about Christine Garner, the 62-year-old widow who'd spent 2 decades in real estate and understood exactly how documents work, who'd positioned herself behind Daniel's shoulder at the will reading like a second in a duel, who'd pushed the hardest and earliest. It takes a particular kind of self-awareness to recognize when you've overextended and pull back before the damage becomes permanent. Christine had that. Whatever else she was not stupid. "Tell her attorney we understand," I said, "and that the documentation stays where it is, as long as the withdrawal is complete and unconditional." Trevor said he would. That Friday, I was in the workshop finishing the final section of the Lady Beatrix hole when my phone vibrated on the workbench. A text from Trevor. 4 words. "Check your email now." I wiped my hands, picked up the phone, and opened the message. It was a forwarded fax confirmation. Prescott Walsh's office to the Sarasota County Circuit Court. A voluntary notice of dismissal signed by Daniel Garner. Dated that day, filed at 4:47 inches the afternoon. The lawsuit was withdrawn completely, unconditionally. I set the phone back on the workbench, looked at the hole. White oak fully caulked the seams, clean and tight. Every plank seated correctly. 7 months of patient work building towards something that would finally float the way it was supposed to. I picked up the finishing brush and went back to work. The court order closing the case arrived through Trevor's office several days later. 1 page. The trust challenge had been withdrawn with prejudice, meaning it could not be refiled. The revocable living trust, established 3 years earlier by Grace and Raymond Foster, executed under Florida Trust Code, Chapter 7:36. Naming Raymond L. Foster as sole trustee and beneficiary remained fully intact and legally unchallenged. 7 properties. Total assessed value, $14.2 million. Mine to manage to sell, to keep, or to use as I chose. I read the order once, then I put it in the folder, with the original trust documents, locked the folder in the safe, and drove to the marina. Trevor called that afternoon. We talked through the remaining administrative steps. The final attorney billing a few loose filings to close out the court record, the status of the vandalism investigation against Caden Garner, which was still pending with Sarasota PD independently of the civil case. One more thing, Trevor said. The GH Advisor's documentation. What do you want to do with it? I had thought about this. I'd had months to think about it. And I had arrived at an answer that felt consistent with everything else. It stays in the safe, I said. I'm not transmitting it to anyone. That was the arrangement. Withdrawal in exchange for the documents staying where they are. Trevor was quiet for a moment. You know that doesn't protect him permanently. Those records exist. If his brokerage is ever audited, or if a former client files a complaint independently, that's not my concern, I said. He knows what he did. He knows I know. That's its own kind of weight to carry. I paused. I'm not in the business of destroying people. I'm in the business of protecting what's mine. Trevor said he understood. I believed him. Send me your final invoice. I said all of it. 3 weeks after the case closed, I listed 3 of the 7 properties with an independent real estate broker. A woman named Sandra Ortega, recommended by the firm that had handled the trust's title work. The 3 properties, the Siesta Key Villa, the Venice unit, and a smaller Gulfront parcel in Naucom that Grace and I had purchased as an investment 15 years earlier and rarely used. Combined listing price $6.1 million. 2 of the 3 went under contract within 6 weeks. The proceeds, once the transactions closed, would fund the expansion of Blue Compass Marina, a new covered storage building, a second repair bay in the workshop, and updated electrical infrastructure along the main dock. Grace would have liked that. She always said the marina was the better investment because, unlike a villa, it did something. Nicole called on a Sunday morning about 2 weeks after the case closed. I filed, she said, the divorce papers. I wanted you to hear it from me directly. I told her I appreciated that. I'm still in Tampa, she said. I kept the studio. I have a couple of good projects coming in. Good, I said. A pause. I know I handled the last several months badly. I didn't tell her she was wrong because she wasn't, but I also didn't press it. That's a different kind of conversation, the kind that doesn't need to happen all at once. Come down sometime, I said. I have a boat that's almost ready to launch. She said she would. I believed her about that too. As for Daniel, I heard through a conversation Nicole mentioned in passing that he had relocated to Orlando. His Tampa brokerage license was still active last I checked. Whether the GH Advisor situation would eventually surface through other channels wasn't something I could control, and I had long ago stopped trying to control things I couldn't. The folder was in the safe. The safe was locked. That was enough. The Lady Beatrice launched on a Saturday morning in late October from the slip at Blue Compass Marina I'd reserved for her since the restoration began. My dock manager helped with the lines. Sandra Ortega, who I'd invited on an impulse, stood on the dock and watched. A couple of the regular marina members came out to see. The hull sat in the water exactly as it should. The white oak planking held. The seams I'd caulked over 7 months were tight and even. She was a 4 2-foot catch built in 1961, and she looked it not restored to showroom condition, but restored to working condition, which is a different and better thing. I stepped aboard, cast off the lines, and took the wheel. The channel out of the marina opens onto the Sarasota Bay, and beyond that the Gulf. The morning was clear, the water green-gray, the air carrying the specific salt weight of a Florida October, warm enough to be comfortable, cool enough to remember that the year was ending. I steered the Lady Beatrix through the channel markers past the other boats at their moorings out toward open water. The engine ran smoothly. The hull moved through the water the way a well-built wooden boat moves, not cutting through it but belonging to it. When I was far enough out that the marina was a small shape behind me, and there was nothing in front but water and light, I cut the engine and let her drift. 7 months ago I had sat in a leather chair in Sheila Vasquez's office and watched a man announce with complete confidence that I would receive nothing. I had said 4 words. The room had gone quiet. I thought about that now. Not with satisfaction exactly, but with the particular clarity that comes when something is fully finished. The trust was intact. The properties were mine. The lawsuit was dismissed. The man who had spent 9 years treating me like a problem to be solved was in Orlando, with a smaller life than he'd expected, and I was on a restored wooden boat in Sarasota Bay on a clear morning in late October, with nothing to do, and nowhere to be. I stood at the wheel for a long time watching the light on the water. Then for the first time in a long while I smiled. If you like this story, subscribe to our new channel and listen to several stories there. You will find a link to it in the collaboration or description of this video or in the comments. Subscribe so you don't lose us because this channel will soon cease to exist.